All right, whenever you're ready, Mr. Lee. Do you want some rebuttal time?
Yes, Your Honor, I'd like 3 minutes for rebuttal.
Okay, you got it.
All right, thank you. May it please the court, my name is Brian Lee. Have the privilege of representing Lorraine Hammer on this petition for writ of certiorari. This is a specific issue that we brought by petition dealing with Rule 1.360 and the requirements under that rule, specifically as to the testing that is going to be performed by a psychologist in this case on Miss Hammer. The rule that we're talking about, court's familiar with, it says that the request shall specify a reasonable time, place, manner, conditions, and scope of the examination. The scope is what we really are dealing with in this case
Yeah,
because,
well, I'm going to
yes, Your
interrupt you
Honor.
because I want to make sure in reading through the requests and the objections and the hearing transcript, there were a lot of things that were raised that you all thought was objectionable. But as I'm understanding your petition and the arguments before us now, really what it boils down to is your problem is they put a list of these are the tests that may be performed, nothing beyond these, but the doctor may decide not to do all of these. And that's really your problem.
Correct, Judge. I think it's a sort of a dual problem here is that yes, that we believe that the actual notice itself, because of that, we did not comply with the strictures of the rule as well as the cases. And as well, there's also an element of the trial court not getting the respondent to do what they were supposed to do, meaning to do that. So I guess it's really sort of a dual thing, but it does involve that particular disclosure under the notice.
So the notice
Okay.
basically says we're going to do these tests, which include but are not necessarily limited to, and then a list of tests, right? I mean, that's your
Uh,
problem, right?
Sure, and
So,
I would
so
clarify. I'm sorry. Go ahead, Judge.
that's
I,
okay. Yeah,
I'm
yeah. Let me
jumping.
just finish my total because you answered the first part. The second part would be then, I'm not a psychologist. I don't really know how this stuff works, but I can envision a psychologist getting a result on one test that leads them to say, well, gee, we guess we need to take this other test. So it's sort of like, a search type process based on what these results show. And I don't know that it's reasonable or that the rule requires that we micromanage this psychologist to say, we're only going to do these two tests. Because if the results of those two tests cause that psychologist and their expertise to say, gee, we need to do another one of these tests because now we have this result that indicates that. So I think you're asking too much. And I don't think the rule requires what you're asking.
So obviously, I would respectfully disagree with you, Judge Morris, and here's why. We can look at first at the notice itself because I think that's kind of where everything comes off of. The notice doesn't say that Dr. Demery is going to do this testing, is going to perform these tests, but that he might not perform all of them. What it says, and I'm reading from it, it says he reserves the right to subtract tests based on information, and that the list of tests that may be administered include, but it does not exceed, it says that, the following, and it lists 9 tests. And so
Mr. Lee, isn't the
sure.
problem in the cases where the notice says we're going to do these, but we reserve the right to maybe do some different ones depending on how these come out, and you're uncertain as to what additional tests that aren't named might be performed, whereas here the entire universe of tests that could be performed were named, and the doctor reserved the right, like, okay, I do test A, and now I know because of test A, I really don't need to do one of these other tests on this list. So there weren't any unknowns. In other words, there weren't tests that we don't know if they're going to do them or not because they're not in this list. All the possible tests were in the list. Is that right?
I think yes. As what was told to the judge and what's in there, it says not exceed. So yes, the universe of tests, which I
Okay,
guess was these 9 testing, what was within the notice.
and I know
Um,
I'm sorry I'm interrupting you again,
no,
but I've got this on my mind. I don't want to forget. I know both of you have said, yeah, we've got irreparable harm because it's psychological testing, and I
yes,
get that. But I come to a more granular level on harm, which is how is your client harmed if the doctor says, I'm going to do these 10 tests, but then only does 9? How is that? What is the harm there?
Judge, the way I would answer that is the harm is not the fact that, a psychologist says, I'm going to do 10 tests or 9 tests, and I only do 8. That's not the harm. The harm becomes at the outset of it, which is that a plaintiff is allowed, and ultimately it is required under Rule 1.360 to know the testing that is going to be performed. And the problem that it happens, and this is part of what the Espinoza case talks about that we cited to the court, unless the movement specifies, this case defendant, the scope of it, right? That's what good cause means. And it goes further and says that if the trial court does not know the particular examinations, then it's not supposed to grant the request. What the problem is—
So the doctor just said, I'm going to do all 10 of these, whether I need them or not, we're good.
Yes. I mean, frankly,
so your
Judge—
problem is that the doctor wanted to not do unnecessary testing.
No, the problem is that we don't know what he's going to do. We don't know whether he's going to do all 9 or none of them, because this examination, this notice gives him the ability to do all 9 or 0.
I guess your position that sort of assumes it's knowable in advance which test he's going to need to do.
Correct.
So that's either that, or he just has to do tests whether he thinks they're necessary or not.
Well, that would
solve the problem. I'm just going to do all of them, whether I need them or not. I'm doing them all.
Right, Judge. But I guess the issue here is that he doesn't say, I'm going to do all 9 of these tests, and then the trial court says, okay, I'm going to let you do all 9 tests, and then he later decides, you know what, I'm not going to do a test. We wouldn't be coming, obviously, to the court if he said, I'm doing 9 tests and I only did 3. I'm not going to say that was somehow harmed my client. The problem is that at the outset, we are entitled to know what testing is going to be done. And this is not— psychological testing does have a special place in the law. And Your Honor mentioned, I think it was either you or Judge Morris mentioned this. It is one of the few things that I have seen where an order granting a psychological examination, like per se, is irreparable harm, meaning that it could be irreparable harm. There is very few things that is the case. And I think the reason is, when you look through the case law, is that not only is the plaintiff, the defense is required to tell a plaintiff which they are going to do because of the fact that the tests themselves are harm. It's not like the examination.
But I guess I'm a broken record, because the mental hurdle I'm having difficulty with is, what is the problem with not doing an unnecessary test? In the course of this examination, he administers tests from this list and decides that some of them are unnecessary, which goes to your cause argument. If anything, the doctor decides, well, I don't have good cause to do this one, I'm not doing it. So the hurdle for me, and just help me with it, is—
Sure.
I don't see, I don't want to sound facetious, but I'm listening to, well, he may not do all of these, and my gut feeling is, well, so what? Like, what is the problem? So help me understand why that's a problem.
Sure. And I think that when we get to the point where the psychologist is deciding, like within the moment of doing the examination, that's not where the harm happens. Okay, because we have already gotten past the point where the notice is required to be given, and the trial judge has the duty under the law to not just look at sort of a general notice. The trial judge actually has a duty, and this is sort of through the case law, it says that the trial court has to determine that the particular examinations that the psychologist is going to do, that it has good cause, and not just to do blanket, whatever the psychologist is going to do, they're going to do. It's to do the particular examinations that are
Mr.
there.
Lee?
I'm sorry, Judge Lucas, go ahead.
Can you reframe that a little bit for me?
Sure.
How would it, how could it be a departure from the essential requirements of law for a court to allow a psychologist to do a less invasive and intrusive compulsory exam? Like, how do you square that with a departure of essential requirements of law?
I'm trying to get on the same wavelength as you, Judge Lucas. So
Sorry, Anna,
I
I'm
apologize.
trying to
and
put
it's
this in a
probably
certain
me, myself.
context.
Right. So the context that I maybe framing it is will be helpful. The context that the trial judge did was the trial judge did not say, I looked at all 9 examinations and I think every single one of them he has good cause for it. And therefore, Dr. Demery, you can do all of them or nothing. What the trial judge did in this case is that it found that these are the tests that could be performed, and that it essentially gave to Dr. Demery what the trial judge should have been doing from the beginning, that you determine what's good cause for you to do to the examination, not me. I'm speaking like the trial judge.
Right.
So the trial judge kind of pushed it off on Dr. Demery and saying, Dr. Demery, I see all the exams you're doing. You decide which ones are good cause for you to do. And I'm going to allow it to happen. This is and the problem with this, Judge, is obviously we're dealing with 9 exams. Or 9 psychological exams, some of them very extensive exams. The MMPI is a extremely extensive exam. But this type of order, this type of, I guess, view of what 1.360 in the cases talk about, it is very easy to see a trial judge, if a defendant files a notice with 100 exams and says, I'm going to do these, it's not going to exceed these 100, but I might do any of them. I have basically the wherewithal to do them on my own. A trial judge then saying, okay, Dr. Demery, you're the expert, you're the psychologist, and so you get to pick which ones you're going to do out of that 100. Now, I don't know. No, it's not 100 in this case. It's 9.
Yeah, no,
but it's the same type of analysis. Not helping you. I'm sorry, Judge. Right.
It's okay.
So, but what I'm trying to say is that the trial judge at the outset has the duty under the law to determine whether the notice is sufficient, and it's got to be specific under the law. The trial judge has she has to look at the examinations and find that they're good cause for the examinations. Not that there's just overall good cause for an examination.
I mean, but the level of, it's so didactic. You're basically like, you could really get that finely tuned and say, you know what, Judge, it's not specific enough because the notice says the MPI, but it doesn't say what version or year of the MPI test that we're going to use. And so therefore it's a departure from the central requirements of law and cert is appropriate. I mean, you could really micromanage the heck out of this. You know what, you need to just include all of the questions that you're going to ask in each of these, because some of these tests, depending upon what version you use, are going to have a broader scope of questioning, some of them narrower. I think your suggestion kind of brings this to a halt. It grinds all this to a halt and basically would require, as a matter of extraordinary relief, would require a trial judge to basically, like, I don't know, oversee the psych exam. And how does that get fixed?
Yeah, and I'm not saying that, Judge Lucas. What I'm simply saying is that I believe that the case law and the rule requires that a defendant say, my psychologist is going to perform these examinations. Even if they say that he believes he is going to perform these examinations and list them. And the trial judge then is able to say, the list that he's given to me, I find good cause for those. That's really all I'm saying. I'm not saying that the judge then has to go into, now, frankly, Judge.
Well, let me stop you, sir. Are you saying you have to go through each test and establish why? I mean, this is a notice. It's to put you on notice. But now am I understanding you that you have to establish each test, why there's cause for each test individually?
That's what the law says, Judge. That's what under the so we're dealing with Espinoza and Maddox, and we're talking about that the disclosure of the actual examinations that they're performed, and without knowing those under, I think, Maddox as well, it says that the trial judge has to be able to say that there's good cause for each of the like the testing. That's what a trial judge has to be able to do. That's the reason why their notice is there, is so that the trial judge knows exactly which tests are being performed, not just the plaintiff, but the trial judge too, because the trial judge then has to make that analysis and say whether that testing is sufficient, whether there's good cause for the testing, because trial judges do have the ability, if there's one test listed on a notice, the trial judge has the ability to go in and say, I don't believe that test that the psychologist is doing is good cause for that. And now, again,
whoa, wait.
Yes.
Just spontaneously the judge or a party presents an argument?
No, and I frankly, Judge,
I mean, then
think
are we bringing the doctor in? Are we getting into expert testimony on why you need this one, why you don't need that one? I'm trying to understand how that would work.
Yes, Judge, and I've done some of these before, so I can tell you exactly how it works. There has been situations where a request is done and the psychologist says, I'm doing these exams, these three. Mm-hmm. We challenge one of them and say there is not good cause for that examination. It is the movants, meaning the defendant normally, it's their burden to show good cause for that testing. And so the movement then normally what happens in this case, Dr. Demery might submit an affidavit and say, here's why I'm doing this testing. Here's why there's good cause for it. Here's what I'm looking for with this. And then the trial judge then has the ability to take that testimony, it might be live, it might be affidavit, and say, okay, I'm finding good cause for it because of what this is. That's the typical process. That's done quite often in these. And I think psychological testing, it's done that way because of the fact that it is a subset of its own, rather than a testing, a medical testing where judges, I think, are more familiar, with things like, if you wanted to take an x-ray, okay, so to speak.
I just want to let you know you're at 17 minutes.
Okay. Thank you, Judge. I'll reserve the rest of my time.
Let you use up all your time, but
thank you, Judge.
However you want. Okay. All right, Mr. Ryder.
Thank you. Good morning. May it please the court, Jack Ryder on behalf of Standard Fire. Your Honors, Rule 1.360 sets forth the limitations and requirements on a notice for this kind of an examination. It talks about it must be specified the time, place, manner, conditions, and scope. And here, where the petition here fails is that there is no demonstration of a departure from the essential requirements of law. As Judge Lucas pointed out, or as he alluded to during the colloquy with Mr. Lee, this notice, which explicitly says that the following 9 tests may be administered, but will not exceed these 9, and lists those tests. We have not heard, first of all, I'd point out that the plaintiff petitioner has acknowledged that Standard Fire had the right to take this examination. There's no challenge to the good cause. There's no specific assertion that any one of these tests of the 9 that are listed are somehow improper. There's been no challenge in the petition suggesting that any of these are not appropriate under the circumstances. And so, quite honestly, and Judge Morris, as you pointed out, I mean, we can't, I would respectfully submit that when a psychologist or a neuropsychologist or any professional is undertaking one of these examinations, they can't be constrained to the point where they can't be told, you must perform these tests, when here we talk about providing the universe of tests. And again, this is not about 100 tests with no certainty as to what might be provided or performed. There were 9 tests listed. The notice explicitly says it will not exceed these 9 tests, and therefore it captured or presented this very limited scope. And I would say, and Judge, Kelly, to your point, I agree that there's no harm here, right? It's not a harmful result. Now, I will acknowledge, and this is why in our response we noted this, because you mentioned during counsel's argument that we both noted the existence of harm, and I want to clarify that. So as I interpret the case law in this arena, the fact is that if there was a departure from the essential requirements of law, then this is in fact the nature of an order that would be subject to immediate review by a writ of certiorari. And we often see cases where you never get to the point of the entitlement to a writ because there can be no irreparable harm because it can be evaluated and reviewed on plenary appeal. So I think the acknowledgement there is simply to say that this is a type of order that is subject to review by a petition for a certiorari. But that doesn't mean that the petitioner is relieved of their obligation to demonstrate, number one, a departure from the essential requirements of law, and 2, the irreparable harm because of that departure. Here, there is no departure, so we never get past the first question. And so I would also submit that, quite honestly, because there's no departure, there's no irreparable harm in the sense that the fact that a doctor conducting this exam decides to do 5 tests instead of 9, or decides to do 3 tests instead of 9, or decides to only do 1 test, there's no harm there to the petitioner. So there is no harm that results from this type of protocol. There is no harm that results from the notice as provided, but quite frankly, it fails at the first instance because there is no departure from the essential requirements of law. I just will note, there's multiple cases cited in the petition. We have dealt with them in our response. There is no case that I have seen and that petitioner has cited that would support the idea that a notice that says the following tests may be given, but will not exceed this list, that constitutes an open-ended, carte blanche type of notice that subjects a petitioner to an array of psychological examinations. Every case that has been cited talks about an open-ended list. This list, to the contrary, is a closed list. It says, here are the 9 tests. That's the entire universe. There will be no more than that. Might be less, but no more. So once again, unless there are any questions, I ask the court to deny this petition and find both that it does not depart from the essential requirements of law, and to the extent that the court even goes beyond that, it certainly causes no harm to the petitioner. Thank you.
Thank you. Okay, Mr. Lee, you've got your 3 minutes.
Sure. I'm just going to come back to one thing. The respondent says, well, there's no case that says that we can't do this, essentially. As part of it, I would say to that it is not the plaintiff's burden to prove that the examinations are not good cause. The burden is on the person who is seeking the examination to prove themselves that there's good cause. And there is no case that I know of that in Florida that says that they can do that by giving a list of tests, saying here's all of them, but we're not going to actually tell you whether the psychologist is going to perform any or all of them. And that's sufficient for a notice. We would say that it is not sufficient. It does not go with the spirit of the rule, doesn't go with the spirit of the cases. And it would be putting both plaintiffs and trial courts in a situation where they would be going into a psychological examination not knowing whether any tests were going to be performed, regardless of a notice that was done. That, we believe, is irreparable harm. It's against the essential requirements of law. And that's why we ask this court to grant the petition and quash the trial court's order. Thank you.
Gentlemen, thank you. Thank you both.